Hi there, I'm Nick Gadd, the Communications Manager of the VLRC. This is a presentation to tell you the essential information that you need to know about the Victorian Law Reform Commission, how it works, what its functions are, and why we even need a Law Reform Commission. The VLRC is an independent agency. It's not part of the government and it's not party political. Its job is to make recommendations to the state government, the government of Victoria. Of course, the VLRC only looks at Victorian laws. There is an Australian Law Reform Commission that looks at federal laws. So the VLRC does not look at things like family law or Australian constitutional law because those are federal. We just look at Victorian state laws. And the VLRC receives its funding from the state government. It was established by the Victorian Law Reform Commission Act and began operations in 2001. The VLRC is the central agency for law reform in Victoria. It's not the only one. You'll need to be able to compare the VLRC to a Royal Commission, for example, or to a Parliamentary Law Reform Committee. They have significant differences to the VLRC. The VLRC is the central permanent agency for reviewing laws in Victoria. So where do the VLRC's inquiries come from? There are two answers to this. Many of our inquiries are given to us by the Attorney General of Victoria. The Attorney General is the Chief Law Officer of the state, a Member of Parliament and a Minister in the government, responsible for the justice system and the courts and the prisons and all that. At the moment, the Minister is the Honourable Jill Hennessy MP, and the Attorney General can ask the VLRC to review any area of Victorian law. The other place that we can get our inquiries from is when they're suggested to us by members of the community. We call these community law reform projects. Any member of the community can make a suggestion to the VLRC for an area of state law that they think should be reviewed. The VLRC will consider these proposals and will choose the ones that it thinks are appropriate. So what are the functions of the VLRC? Well, they are set out in that Act that I mentioned to you before, the Victorian Law Reform Commission Act 2000. Section 5 states the functions of the VLRC. This is the first one: to examine, report and make recommendations to the Attorney General on any proposal or matter relating to law reform that is referred to the Commission by the Attorney General. So that means the Attorney General asks the VLRC to look at an area of law and we review it and then we write a report. An example: the contempt of court inquiry which we completed in 2020. The next function of the VLRC uses similar words: examine, report and make recommendations to the Attorney General. But this time it's about relatively minor legal issues of community concern. So this means the community law reform projects that I mentioned before. These are not referred to us by the Attorney General. They're suggested by the community. An example: the Neighbourhood Tree Disputes Inquiry, which we completed in 2019. The next function of the VLRC is that it can suggest to the Attorney General that a matter relating to law reform should be referred to it. It's up to the Attorney General whether they decide to take that advice and refer the matter to the VLRC. D requires the VLRC to monitor and coordinate law reform activity in Victoria, and E requires it to undertake educational programs, which means to educate the community about law reform in general and about specific projects. So those are the 5 functions of the VLRC. Here they are again. If you were asked a question in a SAC or in the exam about the role of the VLRC or the functions of the VLRC, this is what you would need to know to give a complete answer. We've put the keywords there for you in bold. So what are some reasons why we need a Law Reform Commission? Why do laws need to change at all? Well, there are various reasons. Maybe you've discussed this in class. The fact is that many of the laws that we have today are very old. They've been around for a long time. There have been many changes in technology, there have been many changes to society and changes in social values. All of these may be reasons why laws may need to change. Changing social values and attitudes have led to changes in the law in many areas. For example, the rights of people in same-sex relationships. We now have laws against discrimination on the basis of race, gender and sexual orientation. Abortion has been decriminalised. These are just a few areas where the law has changed in response to changing social values. Advances in technology mean that the law needs to change in order to stay up to date. Advances in smartphones mean that we now need laws, for example, in areas such as data security, hacking, surveillance, sexting, to name just a few. Sometimes the law is not dealing with a specific problem in society. This is the case in Victoria with neighbourhood tree disputes. When neighbours have a dispute about a tree, the law is unclear and confusing as to people's rights and responsibilities. That's why the VLRC took on neighbourhood tree disputes as a community law reform project. Sometimes the law has become so complex and confusing over the years that it is no longer workable. This was the case with the law about judges' directions to juries. This is what a judge is required to tell a jury about the law during a criminal trial, what they have to tell them about the rules of evidence, for example. These rules had become so complicated that the law was no longer really working well. Trials were going on far too long and there were too many appeals. The VLRC carried out a review of this area of the law and recommended that judges' directions should be simpler and clearer. This made the law more workable. And that, in a nutshell, is the role of the VLRC. To look at laws that are out of date or not working well, for whatever reason, and to make recommendations for reform, to make the law more up-to-date, more workable, fair, and in touch with community values. The VLRC has three important principles which guide the work that it does. The first one is that the VLRC is independent. That means it's not part of the government, it's not part of that whole political process. So when the VLRC conducts an inquiry, it is not thinking about political concerns, but thinking about what will make good law for the community. Compare that with the Parliamentary Committee for Law Reform, which is made up of members of Parliament. The VLRC is also independent of the legal profession and the judiciary, although we may consult with judges and lawyers as part of an inquiry. This independence is important. It means that the VLRC can make recommendations which are free from political bias. The second principle is that the VLRC is inclusive. That means that when the VLRC conducts an inquiry, it spends a lot of time consulting with the community to find out what people think about the issue and about the law. The VLRC asks people what their experiences have been, how they've been affected by the law, and how they think the law could be made better. An important part of that is speaking to people who are disadvantaged, people who might normally not get their voices heard. People like Indigenous people, people from lower socio-economic backgrounds, and people from a wide range of cultural backgrounds. It's important for the VLRC to be inclusive and to consult with as many people as possible, because the law is for everyone. Everybody's affected by the law. It can't just be slanted towards one particular group. And the third principle, the VLRC is innovative. The VLRC finds new solutions to legal problems. Victoria was the first state in Australia to legalise medicinal cannabis based on recommendations by the VLRC. That involved designing a whole new scheme to enable the state government to do that. When the VLRC looked at contempt of court, it had to consider how changes to smartphones and social media had affected the law and come up with new solutions. So who are the people who make decisions at the Commission? Well, this is the Chair, the Honourable Anthony North QC, a former judge of the Federal Court of Australia. He's joined by 7 part-time commissioners. The Chair and the commissioners are the people who decide what recommendations the Commission makes, which get published in the VLRC reports. And these are the people who currently make up the Commission as of April 2020. They're all appointed by the Attorney-General for terms of up to 4 years. You don't need to know their names, but it's interesting to see the diversity of backgrounds that they have. Some have worked in public prosecutions, others have worked for various legal organisations or as academics. I'm going to take you through the steps that the Commission goes through every time it conducts an inquiry. You can also find a chart of this process in the Law Reform in Action booklet. It begins when the Commission either receives a reference from the Attorney-General or begins a community law reform project. In each case, there'll be terms of reference. This is a written statement of what the Commission is going to be looking at and when it will deliver its report. If the inquiries come from the Attorney-General, then the Attorney-General supplies the terms of reference. If it's a community project, the Commission writes its own. The next step is when the staff of the Commission carry out their initial research and their preliminary consultations. The purpose of this is to scope the project, to look at important legal cases and important pieces of legislation, and to start thinking about what the problems are with the law. The Commission will also form an expert panel. This is made up of people who have special knowledge that might be able to help. When the Commission did an inquiry a few years ago into crimes and mental impairment, the expert panel included people like psychologists, psychiatrists and mental health professionals who could give the Commission advice about those matters. The next step is the publication of a consultation paper. This is a statement of what the law is at the moment and what the problems are. It does not include recommendations at this stage. What it does include are questions. These are questions addressed to the community and the public, asking, what do you think the law should be? What have your experiences been? The consultation paper will also call for submissions. A submission is a written statement of what somebody believes should happen. After the consultation paper has been published, the Commission will go out and hold consultations with the community. This means talking to people about what their experiences have been, what they think needs to change, what their views are. This is a really important part of the process. Remember, I said that the VLRC is inclusive. So the VLRC will go out and consult widely all over Victoria, talking to as many different groups as possible. At the same time, staff members will be doing research into the law, looking at academic research, looking at legal cases, looking at what happens in other countries and other states. We research extensively, and we generally take quite a few months for this step. Then, by the deadline, the submissions come in. And these are written statements, as I said, of people's responses to the questions. Again, it's a very important part of the process because this is how the VLRC finds out what the community thinks. Another way that the VLRC will get public responses is through online surveys, which is a kind of a quicker and easier way for people to say what they think. So now the Commission is ready to make its recommendations. The Commission uses all the material that it's gathered, the research, what it learned in consultations, the submissions, the survey responses that have come in from the public, the advice of the expert panel. The Commission uses all of that and writes a report containing the recommendations. And what happens to this report? It is delivered to the Attorney-General. Now, by this stage, the Commission has completed its part of the process. But of course, the law has not changed yet, because only Parliament can change the law. So, after the report has been delivered to the Attorney General must table it in Parliament within 14 sitting days. Tabling is the word that is used for officially presenting a document to Parliament. After it's been tabled in Parliament, then the VLRC can publish the report on its website and make it publicly available, but not until it's been tabled. After that, the government needs to decide what it wants to do with the recommendations. The government can choose whether it wants to implement some of the recommendations, all of them, or none of them. It's totally up to the government. The VLRC has no role in that. If the government does decide to, for example, introduce new legislation, then you'll go through the normal process. Parliament will debate that legislation, and if the legislation passes both houses, then the law will change. That process may take several years, so it can be a number of years after the VLRC delivers its report before the law actually changes, if at all. One thing you need to think about is how effective is the VLRC at influencing law reform. One thing to consider is the number of inquiries that the VLRC has commenced, 41 since 2001, or roughly 2 a year. How often have they been implemented? Well, in more than 75% of cases, the recommendations have been implemented in whole or in part. Although, as I mentioned just now, it can take several years for recommendations to actually become law. For the VCE, students of legal studies need to be familiar with some inquiries of the VLRC within the last 4 years. Here are the recent inquiries completed by the VLRC since 2017. Students need to be familiar with at least 1 or 2 of these. This concludes this part of the presentation, which has been a general overview of the VLRC. In the next presentation, we're going to look at one case study of a VLRC inquiry.